So hi, my name is Kiva Richard and I will be doing our last presentation, number 3, the comprehensive research demo for legal writing and research here at University of Memphis. This is for Ms. Johnson's 4150 Legal Writing and Research 2 course. The very first thing I'm going to do is log in to Westlaw. Next thing I am going to do, of course, is to agree and continue. And I want to be able to choose a state's database that is not Tennessee. To do that, I just tap right here and I'm going to select Louisiana to start. Next thing I'm going to do is go to the Tools tab and I am going to click on the West key number system. And when I am looking over the list, I have so many different choices and these wonderful key numbers are a system that it's a master classification system of U.S. laws and are widely regarded as the correspondence of effective legal research. And so since it is Louisiana, I think that usually, since I am from there, as always, the intoxicating liquors gets me. So if I click on this little eye right here, if my iPad, there it goes. It lets me know what exactly that key number should hold. So the subjects are going to include regulations and prohibitions of the manufacturing, sale, and use of intoxicating liquors, the rights of property and traffic of such liquors, injuries from the sales, and unlawful dealings. So I'm going to go ahead and click on intoxicating liquors. It's going to bring up that key number for me. And then if I'm scrolling down, looking at all of these wonderful options, and so this previous, let's just go back one screen. All of the key numbers, the West key number system, all of these are going to be called my digest topics. And so the topic that I am going to choose, of course, was that intoxicating liquors. Another thing that we would say the digest system is, the digest serves as a subject index to the case law published in the West Reporters. So if I am going through this, we have sales without license, sales without bonds, penalty imposed. The thing that interests me the most, I would have to say, would be, let's see, who's liable for civil damages? So in general, who's liable? Just let that come up right quick. And if I'm looking at this, we have this head note. And the head note is just going to give me a quick preview of what all that case is about. And it says the immunity from liability under the host liability statute is limited to those bar owners who serve or sell alcoholic beverages to persons over the age of lawful purchase, therefore, and thus, when a bar employee serves alcohol to a person under the age of 21 and that person causes damage because of his intoxication, statute does not immune the bar owner from liability. However, neither is the bar owner absolutely liable. So that one is from this wonderful case right here. Rombly and Giglio. Of course, those are some real great Louisiana names right there. So next we are going to do, we just went over the head note under it. And next we are going to change jurisdictions. So assuming that I did not mean to look up things in Louisiana, but I meant to look them up in, let's go with Mississippi, because I have family that lives there. And we're going to hit apply. We are in literally the same exact digest numbers. So we have intoxicating liquors, civil damage laws, persons that are liable, and then in general. And we have these two cases right here from 1985, which it looks like just about exactly the same case. And the statute making it unlawful for any permittee or other person to furnish alcoholic beverage to persons who are visibly intoxicated did not apply to the situation in which a social host allegedly served beer to an individual who was intoxicated and thus provided no base for the host liability to the third person injured by acts of the intoxicated individual. So that was us having the same exact subtopic and key number in a different jurisdiction. Since both of these cases are from 1985, I'm going to go ahead and just change my jurisdiction back to Louisiana, because I know that those cases can be filtered by different dates. And so we are going to change the filter. We are going to find a case that is after, let's go with 2009. Oops, not 22, but let's see. We want a case that is after 2009. So it's going to update our results. We still have 24 results of cases that are after 2009. I want to just make sure we did that. So all dates after 2009. And we're going to hit go, just make sure it updates properly. Okay, so all our cases should be after 2009, but they still are not. Let's try before. Actually, let's try a specific range. Let's try cases before 2015, but after 2009. There we go. We have one case from 2009, and it is from the daiquiri affair, which of course is a daiquiri shop. So even if the vendor or host sells or provides alcohol to an underage drinker, that person causes damage as a result of the intoxication, no absolute liability attaches to the vendor or host. Rather, courts utilize the traditional duty/risk analysis to determine whether the vendor or social host violated general negligence principles. And so we're just going to remove this filter, just undo that filter completely. And this time we are going to filter by jurisdiction. So I just want to look at cases from, let's go with the First Circuit. So this case actually came from the First Circuit. And we have a couple of more. First Circuit apparently is Baton Rouge, which is what I was thinking. That's where our capital is in Louisiana. So we have this one, social hosts was exempt by statute from any liability for injuries sustained by a social guest who allegedly blacked out after drinking 2 alcoholic beverages over the course of 4 hours and was involved in an automobile accident. Guest had not claimed that he had been forced to consume alcoholic beverages or that the host had falsely represented the beverages did not contain alcohol, as required to come with exceptions and exemption statutes. So we got it limited down to one jurisdiction. You can even take and limit it down, and that's underneath the Court of Appeals. We could just limit it down to like the Supreme Court if we really wanted to, which would just be one courthouse, but being underneath one, the First Circuit Court of Appeals is in Baton Rouge. So next we are going to open this one opinion over here that we just read. You just do that by clicking on Hollis v. City of Baton Rouge. And then we are going to, it took me to where the keynotes were in the case. So there was no evidence. That took me exactly to where that note was. So it's right here on the second keynote, which is what's associated with the 299 in general. So the weight and substance. So we're going to look at the opinion of this, little synopsis. So opinion. Plaintiff David W. Hollis appealed the granting of summary judgment in favor of the defendant, State Farm Fire Casualty Company, also known as State Farm, dismissing his claims for injuries allegedly caused by State Farm's insurer, William. The plaintiff filed suit for injuries resulting from an accident which occurred after the plaintiff was served 2 alcoholic beverages while visiting William's home. And this happened in 1987. So we want to take and just click on one of our head notes. So let's click on number 2, which is the one. And so it takes us exactly to where it's at. We further find that the defendant did not offer any evidence of a disputed material factor which would tend to establish that William